Good evening. My name is Greg Cunningham. I took the position that all three cases, Griswold, Roe, and Casey, were decided incorrectly. I'll handle each of these in turn. The matter of Griswold v. Connecticut is correct on the judgment, but not on the reasoning. In essence, I agree with the comment from Justice Stewart that the Connecticut statute represented an uncommonly silly law. My position is admittedly colored by a somewhat naturalist approach, tending to favor less state intervention, something akin to utilitarianism. The state has an interest in supporting the institution of marriage and deterring infidelity, but the Connecticut statute was far too broad in support of those ends. And so again, while the outcome I think was correct, the means by which it got there, using the penumbral approach, was incorrect. Now, turning to Roe, this is incorrect on the judgment because there are circumstances in which an unborn child could be deemed a person, in my view, and therefore conferred constitutional rights. Blackmun's textual analysis of the Constitution's use of person is something I had never heard before. It is clever and is persuasive, but it is not complete, or at the very least, it is not dispositive. Our law extends designations of personhood beyond corporal, flesh and blood individuals. So, for example, corporations and other associations of people are deemed to be persons and receive many constitutional rights and protections accordingly. Importantly, these other forms of legal persons do not inherit all constitutional rights. So it's possible to conceive that of in utero personhood endowed with some rights but not others. So, for instance, to suggest that an unborn child, or for that matter, a live baby or a toddler, have anything like a right to property borders on the absurd. But a right to life is not absurd if we can extend personhood to someone thus situated. Now, as the case admits, if we do call it a person, the Roe's case essentially falls apart. And I find it strange or it is strange to suggest that a grown man or woman, a flesh and blood person, has rights. A corporate person, groups of people, which are fictions or creations of paper and ideas, that they have rights, but that flesh and blood person who is unborn would have none. Now, that said, there may be limits. The line may be sentience rather than around mere viability. And I believe Justice Scalia was correct in his dissent in Casey. It's inevitably an issue of a value judgment. But the court is incorrect to have foreclosed on the idea or on the issue of personhood altogether. And accordingly, I believe it was incorrect on the holding and the reasoning at the end of the day. Turning finally to the matter of Planned Parenthood versus Casey, the decision in Casey affirmed Roe, which it naturally could not have done if Roe were not precedent, and Casey is vulnerable to the same criticism vis-a-vis personhood. But those two items notwithstanding, Casey indicates that the right to abortion is justified, at least in part, because of the effect that it has on women's ability to control their economic and social lives. And the court does this while simultaneously holding that changing facts and circumstances may justify a reversal of prior holdings. Now, facts and circumstances have changed. We see the proliferation of labor-saving technology, the availability of childcare, the expanded welfare state, liberality of laws, and all other sorts of social norms and mores, all in the direction of motherhood and economic and social control all coexisting. So there's no reason, in my view, to believe that the reversal on or further curtailments of abortion would serve to reverse all of those trends simultaneously. Thank you.